Our next panel discussion is to reflect on the American Law Institute's principles of the law, particularly in regard to police questioning. And I'd like to start by introducing our panelists this morning. Starting on the far end is Colonel James W. Baker, retired, owns and operates JW Leadership Consulting. Mr. Baker previously served with the Vermont State Police for over 30 years. Having gained an extensive background in all aspects of law enforcement, he was promoted to the rank of colonel and appointed to the position of director of the Vermont State Police on September 1st, 2006. He retired from Vermont State Police in 2009 to start his consulting practice, which he continues to operate and manage today. Through his consultancy and law enforcement career, he has also served as the interim director of the Vermont Police Academy, acting police chief in the town of Manchester, Vermont, interim chief of police for the city of Rutland, Vermont, and he was a project consultant for the FBI National Law Enforcement Data Exchange Program. Mr. Baker has also served as executive support specialist for the Nationwide Suspicious Activity Initiative within the U.S. Department of Justice Bureau of Justice Assistance. He has done extensive consulting for the International Associations of Chiefs of Police, and from 2015 to 2018, Mr. Baker accepted a position within the IACP as part of the senior leadership team, where he worked on national and international criminal justice issues to include the development of the Institute of Community Police Relations and the Center for Officer Safety and Wellness. Mr. Baker most recently served from 2020 to 2021 as the interim commissioner of the Vermont Department of Corrections. He earned a Bachelor of Science in Criminal Justice Management from Southern Vermont College and is a graduate of the 188th session of the FBI National Academy in Quantico, Virginia. Seated next to him is Dr. Allison Redlich, University Professor in the Department of Criminology, Law and Society at George Mason University, where she serves as the Graduate Director and Associate Chair. Dr. Redlich is currently a visiting scholar at the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey Law School. She recently served as president of the American Psychology Law Society, a division of the American Psychological Association. Dr. Redlich is a fellow of the American Psychological Association, American Psychology Law Society, and the Academy of Experimental Criminology. She has received funding from federal grant agencies and private foundations to conduct her research on interrogations and confessions, guilty pleas, wrongful convictions, and mental health courts. Across these areas, she has published extensively, including co-editing and co-authoring 6 books. Her most recent book with Vanessa Edgkins, entitled A System of Pleas, Social Science Contribution to the Real Legal System, was awarded the American Psychology Law Society Lawrence S. Reitzman 2022 Book Award. She currently sits on the editorial boards of 6 academic journals and is frequently asked to provide professional advice, expert testimony, and presentations to the legal community. She is also the recipient of 2 National Mentoring Awards. And finally, sitting next to her is Dr. Brandon Garrett. He is the L. Neil Williams Professor of Law at Duke University School of Law, where he has taught since 2018. Dr. Garrett is also the founder and faculty director of the Wilson Center for Science and Justice at Duke. He was previously the Justice Thurgood Marshall Distinguished Professor of Law and White Burkett Miller Professor of Law and Public Affairs at the University of Virginia School of Law. His research and teaching interests include criminal procedure, wrongful convictions, habeas corpus, corporate crime, scientific evidence, civil rights, and constitutional law. His work, including 6 books, has been widely cited by the courts, including the U.S. Supreme Court, lower federal courts, state Supreme Courts, and courts in other countries. Dr. Garrett also frequently speaks about criminal justice matters before legislative and policy-making bodies, groups, and practicing lawyers, law enforcement, and to local and national media. Dr. Garrett attended Columbia Law School, where he was an articles editor of the Columbia Law Review and a Kent Scholar. Dr. Garrett is on the leadership team of the Center for Statistics and Applications in Forensic Science, and beginning in 2019, Garrett also serves as the court-appointed monitor for the federal misdemeanor bail reform consent decree in Harris County, Texas. My name is Matt Clem. I am the Deputy Director of the Institute for Law Enforcement Administration, a division of the Center for American and International Law located in Plano, Texas. First of all, good morning. Thank you for being part of this panel. We are here today on this panel to discuss ALI's principles of the law and more specifically police questioning within the larger context of bridging the gap between science and practice. In some way, I imagine that presupposes there exists some deficiencies in the common practices of law enforcement used to elicit confessions. I'd like to start with you, Dr. Garrett. You have conducted an extensive body of academic research into the phenomenon of false confessions. Can you help summarize what are the nature and scope of the problem is from your perspective, and whether or not you believe it is just as prevalent today as when you first started studying it?
Sure. I'm not a doctor, just a lawyer. Would it help, though, if I said a little bit about what the American Law Institute is before we even talk about what false confessions are and why they happen? Because we've been talking some about false confessions today. So I think we were asked to come here today and talk about this document, but also how it could help to inform police practices around police questioning. Because the American Law Institute adopted these principles of policing at its annual meeting last May. So the American Law Institute was founded in 1923 based on a perceived need for the legal profession to do something about the fact that a lot of law was common law, quite inconsistent between different states, even on really important topics like evidence, contracts, torts, huge differences between states, and even within a state, many states didn't have anything codified. And so it was hard to know, what the law was, particularly where there wasn't like Lexis or Westlaw. It was in books, you had to read them. And the ALI's initial goal was to kind of create treatises. What became quite famous were its efforts to create restatements of the law, to try to distill common principles across the law of different states. Some of those restatements have just been enormously influential and have themselves shaped the law. They have also developed model codes. The model penal code is really well known, obviously, to folks in law enforcement and in criminal law. Although many states have not adopted, it has influenced the criminal law of many states and helped to kind of push towards more consistent codification of criminal law. The Law Institute, consists of law professors, judges, other kind of legal professionals. Lots of well-known people serve on it. The Principles Project, though, that we're talking about is not a restatement. It's not designed to restate the law of policing across different states. When the ALI does Principles Projects, it's really out of a recognition that there isn't even enough there to do a restatement. That there is a need for sort of basic principles to guide, and part of the rationale was that even as complicated as federal constitutional criminal procedure is, and many of the state laws that regulate police, that those types of rules often provide very thin minimal guidance, a constitutional floor, a minimal legal floor, but that much of policing is in the area of best practices that are not required, but that professional agencies adopt to treat people fairly and to get good outcomes for public safety. And so the idea was we need principles here because restating the law really wouldn't help, that there's a need to build. So that was what this project was all about. These principles cover a lot of topics. Very early on, we released principles on the use of force, which definitely reflected work by leading policing agencies like IACP and PERF and others. Unlike many American Law Institute sort of advisory groups, our advisors included a lot of leading police professionals, both police chiefs, representatives from IACP, major city chiefs. It was a much more police-focused group of advisors, which was extremely helpful to all of us working on the project. One last piece that I want to mention, though, because it's relevant to our topic today, which is police questioning. Well, first, we called the chapter a chapter about police questioning, not interrogation. We intentionally wanted it to cover forms of questioning that are not a custodial interrogations. We thought that the concept of custody in Supreme Court cases is confusing, draws arbitrary lines, that for police to adopt best practices, you need to look at questioning more broadly. So in that sense, the focus is broad. It's to provide good principles to police agencies, but not detailed model policies, just principles on the entire topic of police questioning, which is a huge topic. Now, this is where the focus is narrower than what some of you would want. The focus was on providing guidance to police agencies. So on topics like, when do the products of police questioning come into evidence? What is the role of judges to do gatekeeping to decide when confession evidence is admissible? What happens when the products of police questioning may influence the plea bargaining process, which Allison Redlich has studied? All those things that happen once police questioning flows into our courtrooms, not directly covered by these principles. These principles are focused on police agencies. So it's a little odd that this group of heavily law-oriented people focus so much on police and not on courts, but that was the focus of this project. The AOI has been enormously influential in many areas. Whether these principles of policing will be influential and helpful to police agencies, I guess we will find out. It's still a little early to tell. The people have referred to these principles and cited to them here and there. The final version has not come out yet. There were a few small comments at the May meeting that approved the principles, and so when they are released, I think at the end of this year, maybe there'll be a flurry of activity, maybe not. But I really look forward to any observations that folks in the audience here have if you've read this chapter of our principles, and look forward to the conversation here today. But to answer the question you asked, have false confessions, are they happening more or less now? Who knows? It's not normally the case that confessions get stamped as false or true, and often we don't find out until decades later that something terrible went wrong. And so it's very hard to know how often people falsely confessed. We know a lot about risk factors and why people can falsely confess, but we don't know anything about rates or how often it happens. It's somewhat accidental often when we do find out that something has gone terribly wrong in the interrogation room. Thank you.
Jim, you and I share a background in law enforcement. We've spoken a little bit offline as well. Can you explain from your vantage point what are the goals of police interviews?
Yeah, I think just to follow up on Brandon's point, how did I get here today? I participated in some of the early conversations with ALI when I was employed at the International Association of Chiefs of Police. Look, at the end of the day, wrongful convictions, coerced statements, bad evidence is bad for everybody. I mean, it's just as simple as that. And when I think about this subject matter around, and I agree with Brandon, I'd like to have the conversation in the broader context of the questioning of individuals, not necessarily this term interrogating individuals. Because even questioning individuals, even as a witness, in some circumstances can be very coercive, and bad information can come out of that. And bad information leads to bad outcomes in investigations. So my view on this is that the work that ALI was doing was very helpful to law enforcement from the standpoint of putting into place principles. And it's really akin to me, the work that's been done around false identification and photo lineups. Right? We now know the science of memory has influenced those approaches as well. Mm-hmm. And the approach is entirely different now. If agencies are practicing good practice, when it comes to photo identifications, we know that the science has really shed a light on what I probably did back in the late 70s as a young road trooper when I did a photo ID lineup. I think the other thing, Matt, that I'll point out now, and I think it'll come up again as we talk about this, is that early in my career, and I hesitate to say this, but I'm going on 50 years in the criminal justice system. Early in my career, there was a heavy reliance on getting confessions. You didn't have the kind of evidence gathering, DNA testing, the ability to be able to do better forensics. And so the pressure to solve crimes back in the 70s, 80s, and early 90s really centered on getting a confession. And that pressure led to very bad outcomes. And we know that. And so I think as we move forward, the latest research and work that's been done by Allison and others is really going to be informative to, as Mark Fallon said in the first panel, changing the impression upon law enforcement about how to move forward when it comes to questioning, interviews, and interrogations. And Matt, my final point would be that I think, you know, I was having this conversation at the break, and the question came up in the last panel about how do you change this? And you can probably tell from my resume that I have a hard time keeping a job since I left the state police. But those jobs were really phone calls to me to go into very troubled agencies. And what I learned out of that experience is the behavior you get in an agency is what you're willing to tolerate. And so if you're a leader in an organization, a law enforcement organization, and you're looking the other way when there's bad practices going on in interview and interrogations, that's where the problem is. It's about leadership and setting the bar higher. And so I'll leave it at that for right now, Matt.
Dr. Redlich, ALI states the goal of police questioning is to obtain accurate and reliable information while seeking to minimize the amount of undue coercion and treating persons with dignity and fairness. And I think we can all agree that that's a consistent theme throughout the day, and that's a laudable goal that we all want to achieve within the criminal justice system. But I'm hoping you can help me understand what it means to minimize the amount of undue coercion, and what exactly do we mean by coercion in the first place?
Well, I guess I'll take a step back too. I'm not exactly sure how I got here, except
Me either.
Brandon.
You're good.
The ALI principles are brand new to me. I was able to read Chapter 11 on police questioning before I got here, but and I will say that I agree with about 85–90% of them. It reflects a lot of the literature. But you ask a really important question, Matt, because coercion, or its flip side, voluntariness, has been something that I think the legal system has struggled with for a very long time. You see quotes all the time from legal decisions about how ambiguous these terms are and what does it really mean. Is it objective? Are there these objective markers that we should be paying attention to? Is it purely subjective? Is it really just the suspect's, in this case, perception of what they consider to be voluntary? It brings in issues of custody and how do you define custody. I think what it brings up for me is, the very different definitions of coercion as well, because, as a researcher, I'm dealing with human subject research boards at universities, and their definition of coercion is very, very different than the legal system's definition or law enforcement's definition of coercion. So, we can't pay prisoners sometimes because that would be unduly coercive to have them participate in research. Some other questions, is it any kind of coercion? Is it some degree of coercion? All of these kinds of questions are excellent to be asking, and that, unfortunately, I don't have the answer to, but I do think that it's important for the law enforcement community and the legal community to be grappling with these kinds of issues, because in my opinion, I think that the markers that judges rely on now to admit confessions or suppress them are inappropriate. Typically, they're relying on things like, did the person get food or water or restroom breaks? Or, did they get a smoke break if they happen to smoke? And of course, all of those things are very, very important. And this is actually one of the principles, is that suspects should be getting breaks and food and water and all this. Of course, I agree with those things. But we've known for many, many years, interrogators interrogate using psychological techniques. They're not using these physical third-degree techniques, as we all know, as the system has recognized for many, many years. So to rely purely on these physical techniques, physical markers, I should say, of food and water and those kinds of things, and wholly ignore the psychological aspects, and as a psychologist myself, I think come into play when we're talking about perceptions of voluntariness and issues of custody and those kinds of things. I'm not sure if I answered your question, but.
You did, and
Yeah.
you actually provided me a pretty excellent segue, and if you guys could keep that up, I'd appreciate it. But it actually, it leans into my next question for Brandon. In your research, and particularly your paper, The Substance of False Confessions, you note there are problematic, quote, strategies used by police to induce a confession. Can you explain what those most troublesome strategies are in your research that you found?
Sure, and this relates to what Allison was just talking about. Fortunately, at least outside of Chicago, we tend not to have physical torture of suspects. There's still unwinding, decades of physical abuse of suspects that has continued to come to light out of Chicago, and there may be other places where that's happening. But the third degree is fortunately mostly receded far into our past. But it's far better understood now that psychological pressure can produce false confessions and can also, as I've talked about in my work, make it very difficult to tell what is truth and what is fiction. And it can contaminate confessions, even in cases where it may not be easy to tell whether it is a false confession or a wrongful conviction, but it's contaminated. And so this is in part why these principles talk about the need to just minimize coercion across all the different ways it can happen, whether it's the length of questioning, whether it's deceptive techniques, whether it's sort of the physical aspects like not giving someone food or water. But there's a real accuracy reason because it harms police investigations if you have someone who is fed facts, whether intentionally or not, and you then can't know whether they were able to tell law enforcement about what happened at the crime scene on their own. And it's a problem with witnesses too. You shouldn't be leading witnesses. You want to know what information witnesses have as well. I've always been horrified when I talk to agencies and ask them, what training do you have on just questioning a witness? And they're like, oh, we get read trained. We're trained on interrogations. And it's like, well, wait a minute. Talking to witnesses, you're interrogating your witnesses. You want to know what information they have, not be telling them information. I guess a good illustration of what you see in almost all of the well-known cases where DNA exonerated someone post-conviction comes from just a couple miles from here in Arlington. It was one of the first two. There are kind of two cases that were tied for the first DNA exoneration post-conviction in the United States in 1989. There's the case of David Vasquez, who had severe mental health issues, was quite vulnerable, was questioned on tape by law enforcement. And the case is a good illustration of how recording interrogations isn't enough if when terrible things happen and are documented on the recording, nothing is done about it. So there's a great recording where he's mentally ill. He doesn't really know what they're doing, but is quite vulnerable and sort of just worn down and whatever. And it's been hours. Most people after hours will kind of do what police want them to do. It was a murder case, and they're trying to get him to say how the victim was murdered, which is a key piece of information that the person who was involved should know. And they're like, you strangled her. And so he's like, oh, okay, yeah, I did that with rope. And they're like, no. And he was like, he was really trying. He's like, my belt? And they're like, no, not your belt. And he was like, a clothesline? I mean, he's like proceeding quite logically here. And they're like, no, like the windows. And he's like, what? And he wasn't familiar with window treatment so much. And they finally explained no, the Venetian blinds. And he's like, what is that? And Venetian blinds are not particularly Venetian. I mean, when you think about it, it's really a corruption of anything that you would see in Venice. But he wasn't really going there. He was kind of like, what is that? And they're like, there's a cord on that. He's like, oh, okay. So I used that. So I strangled her. And they're like, yeah. He's like, okay. So I choked her, strangled her. Like, yes. I mean, when you listen to the tapes, it's just ridiculous. He has no idea what's going on. They're aggressively feeding him facts. And it's kind of hard to do that because he doesn't have the background knowledge of window treatments. But once he has sort of caved into their aggressive feeding of facts, his defense lawyer was kind of like, "You confessed. This is a death penalty case. Like you should take a plea here." And it wasn't until a few years later they do a DNA test, and he is cleared. The DNA matches someone else. His defense lawyer may have been right. Like in those days, you didn't have courts like letting in an expert saying, "Look, this is a clear case of confession contamination. This is a mentally ill person, quite vulnerable. Listen to the tape, you can see how they're telling him what to say." The defense lawyer may have been right. Like in those days, a death penalty trial in Virginia might last a day or two. Judges were not very expert friendly. There would not have been much meaningful opportunity for the defense to make a case that this confession was false. But you see contamination like that. There, it was pretty clear that the law enforcement were pretty aggressively and intentionally feeding these facts. But there are many other examples, including the case that James Trainum has famously written about here in Washington, D.C., where he, unintentionally leaked facts during a lengthy interrogation and didn't realize that it happened until the suspect neatly tied it all together at the end. And afterwards, listening to the tape, he realized, oh, wait a minute, each of those 8 facts or whatever, like I disclosed those one at a time and didn't realize that I had done so. So whether it happens intentionally or not, it makes it impossible to then know what the suspect actually knew, and could they actually tell you things about this crime scene that only the culprit could have known. It makes it impossible to test the accuracy of a confession statement. So it's obviously in law enforcement interest to get this right. But that takes more than just recording the interrogation. It requires training and practice around not just not using aggressive deception, but also not leading, not feeding facts. It requires careful attention to fact development during police investigations. And that level of kind of professional care is becoming much more common at larger professional agencies like we were hearing in the last session. And that said, there are many agencies across this country which have a long way to go. So I'll stop there.
Right. Thank you. You took me off script a little bit. I'm gonna tie into something that you said that was really good, but I'm gonna go to Jim for this next question because it seems to implicate what you just talked about. And Jim, it seems to me that a lot of what gets law enforcement in trouble, particularly with these false confession cases, is that there's a confirmation bias on the behalf of the investigator. So the confession itself is not served as another piece of the puzzle to be corroborated, but it's the end of the investigation. Is that a fair assessment of what you've seen in the past?
Yeah, I agree with that, Matt. And I think going back to Brandon's point, as I heard, him retelling the story about the case with, how did you strangle her? I think about it's videotaped, it's on recording, and I'll go back to what I said earlier, and I think it ties to your question, Matt. My experience is that we have made progress in law enforcement from the way we respond to major cases. My young days as a detective in the state police, if you had a homicide, you may have showed up with 3 other detectives. By the time I left the state police in 2009, you had a homicide, you had 45 people there, and you had a forensics team, and there was an overhead management team there. And here's my point, is about when I hear the story about that description of how they led that individual through various scenarios of how the victim was strangled. Where is the supervision and who's watching that video internally inside the agency to go to the prosecutor and say, we have a problem? That shouldn't be years later that DNA clears an individual. And the problem with making the confession the end product, Matt, is that if it is a bad factual confession, with forensics being what they are today, now you've contaminated the evidence, the forensic evidence, by a bad confession, if that makes sense. You've got evidence that's going to conflict a confession, which is not going to make for a resolution to the case, which is what we're supposed to be doing, is bringing justice to the system to include justice to victims. So I think I answered your question about that. And, you know, that's the troubling piece that I find in the circles I travel in, is that, and I hate to be repetitive, if you're in a leadership supervisory role in a police agency, you're going to get the exact behavior you're willing to tolerate. And so if you're willing to tolerate that kind of interrogation, then that's going to be the end product, which is going to be problematic at a ton of different levels.
Yeah, I'd like to open, you know, I want to follow up with that because I think we're focused on police interviews and interrogations. Obviously, that's the topic of our discourse today, but I'm curious too, that same level of confirmation bias can lead, or do you think it can lead to the same issues when you have criminal profiling or composite sketches? I recall one case that I was involved in supervising where we had a DNA composite sketch made, and it looked very much like a particular person that was a focus of interest in that investigation. But luckily, that detective was smart enough to follow the trail and figure out that it wasn't him at all. And so I'm curious if that same confirmation bias can lead to those same issues that police interviews can lead to.
Yeah, I've seen it, right? I mean,
It can affect forensics, like you were saying. Ideally, forensics provide an independent check.
correct.
And, we interrogated someone that confessed, but then we did a wholly independent forensic test. But often crime labs are not, you know, independent. They're talking to the investigators.
Correct.
We've seen cases where you know, the crime lab analyst gets a call and says, you know, the suspect confessed. You don't need to test the DNA.
Correct. I couldn't agree more.
Yeah.
There is that bias there. And I think, you know, Matt, you and I talked about a case in your home state of Texas when we were preparing for this. I think that bias comes from if there isn't a good overhead management team in a major case that's very objective and keep the investigators on task, there becomes this overinvestment of getting the case resolved.
Yeah.
Right?
I'll also make a plea I don't know if agencies do this, but even if it is a crime lab that's embedded within a police agency, we found that just the simple things like the evidence submission forms that crime scene is preparing to send evidence in for testing, often they will have fields that call for all kinds of biasing information. Like there's no reason when you send DNA or fingerprints in to be tested that you need to note the person's criminal history, their race, all kinds of stuff. Like you can actually have, like if you have good quality control in an agency, you can have firewalls there in the same way that you don't tell the suspect key facts. You want them to volunteer the facts.
I agree.
You don't need the firearms analyst or the fingerprint analyst or the DNA analyst to know that the guy confessed or the person's criminal history. They might need to know like what surface the fingerprint was left on. There may be certain facts about the crime scene that they need to know to do their work. Anyway, that's a different chapter of these ALI principles that focus on bias and forensics, but it's all related really. Like it's the same kind of principles that we want work to be done carefully and professionally because it's in everyone's interest.
Yeah, I mean, if you were to ask me, you know, what causes or what leads to a false confession from an innocent person, I think what I would say in a nutshell is this idea of guilt presumptive interviewing or interrogation. So I think everybody here is familiar with these kind of the difference between interviewing and interrogation. And, you know, they claim that, you know, we don't interrogate innocent suspects, which is just really absurd. But like you were saying, if you're going to go into an interrogation presuming guilt, that's of course all you're going to see. So this idea of confirmation bias is that we seek out information that's consistent with our theory. We ignore information that's not consistent. We discount other information that's inconsistent. And, you know, again, how do false confessions happen? You know, my elevator speech, that process. And I know that a lot of the Mendez principles, what you're doing in Aletheia, what the Hig is doing, a lot of it is to get away from that to whatever model of interviewing and interrogation and just to seek out information and to interview people under a presumption of guilt. I think that's very, very problematic, and that's what we need to move away from. I think another thing that we need to do is really address the idea of probability of guilt, which is a little bit inconsistent with what I'm saying, but what is the base rate of guilt, or what's the probability that we need to interview a suspect? Is it when we're just trying to seek out information, or is it when we've already compiled a significant amount of evidence and then we need to put the icing on the cake or something? Or do we even need that if we have all of this evidence? I mean, that's a question that's probably not a very popular question, but do we really need to interrogate suspects? And when there is no other evidence, I think that's really the most dangerous time is when you're interrogating, especially under an accusatorial confrontational model of interrogation, which is the predominant one in the United States.
And we spoke a little bit about that offline, about semantics and definitions matter. And, I hate to say it, but since we're in DC, sometimes you need to know what the definition of is. And so is there a risk of even using the word interrogation in the first place? Does it set officers up for a more adversarial role than should be intended just by using that word? Is that?
Yeah, Matt, as I listened to this conversation, because we didn't rehearse this, right?
No, we did
not.
Clearly we did.
Exactly. As I listened to this, I'm thinking, and again, I come from a part of the country in New England where the courts are pretty restrictive about the way they look at police interactions. And I mean, as I listen to this, I don't ever hear anybody in the circles I travel in refer to as interrogations any longer. It's an interview. And even a suspect is an interview. It's not an interrogation. And I do think that matters because, let's face it, the nature of a police interaction with somebody is got a power differential to it to begin with. And there's a level of influence there as a result of that power differential. So I think if you're operating in that world, you have to be aware all the time that you have a certain persona about you as a police official when you're interacting with someone. Mm-hmm. And so I think it matters if you're calling it an interrogation or an interview. And for me, like I said, the circle I travel in, I don't ever hear anybody use the term interrogation anymore. I hear them use the terms interviews.
All right.
I think that matters.
Well, I think it's also important because of something that's not in the ALI principles, which is Fifth Amendment law, which makes it quite unclear when someone is deemed in custody, mm-hmm. and all of a sudden it's constitutionally treated as an interrogation. Like that line is very blurry. Mm-hmm. We want police to think about interviewing and think about gathering information from people in as uncoercive a way as possible, but the Supreme Court has sort of encouraged a kind of a shell game mentality, which is not conducive to that, where even if you ask a police officer, like, am I free to leave? They don't necessarily have to answer you in a clear way. Right. And it can actually be very hard to, even if you're somewhat well trained, to know, like, well, am I free to leave? Am I in custody right now? Should I be told that I have certain rights to get a lawyer or not? Will my silence be held against me or not? It can be quite clear and unclear. And the Supreme Court has somewhat been intentional about wanting to give law enforcement the maximal tools to sort of use their discretion and decide whether someone is really free to leave, whether they're really in custody, whether they really need to have Miranda warnings and be afforded those rights. And so that makes it very challenging. And by the way, if any of you haven't prepared for today's conference by watching the John Oliver episode on confessions, it's both hilarious and also depressing. Where the examples of going to what Allison was talking about, where officers often feel like, we're questioning this person because the person is guilty. But then the kind of folk wisdom that causes officers to believe that this person is guilty, and that's why we are interrogating, not just interviewing. It's, well, this person is shifty and they're not looking me in the eye. Or the same reference manual may say, well, if the person is looking at you in the eye in this uncanny way, and they're, that could be If they're nervous, that could be a problem, that they're not telling the truth. Or if they're just still and calm, that's eerie. That's I mean, if we actually knew how to look at people and tell whether they were lying or not, that would be like a scientific revolution. Like there is, it would be great if there were human lie detectors out there or machine lie detectors out there. But unfortunately, the things that make people truthful or liars cannot very easily be detected, and no one's an expert at it. Many people are led to believe that they are, and that causes real problems as well.
Allison, you had asked earlier whether or not interviewing a subject is even necessary given the advances in forensic science. What are your beliefs on that?
Yeah, I don't know. I don't know. I don't have the perfect answer to that question. I think a lot of people would be, I don't see it happening anytime soon. I think that it would be so controversial to say that we should no longer interview or interrogate suspects of crime. That, I wonder if we should even, I know I brought it up, but I wonder if we should even be talking about it, because I do think that, I've been studying interviewing and interrogation for about 25 years now, and there's been so much progress that's been made in the research community and in law enforcement for sure. I'd say it's a little bit slower in law enforcement than it has been in the research community, but we've made great strides in terms of building that better mousetrap and knowing what are effective ways and what are ineffective ways and what we should not be doing as interviewers and just really changing our mindset from interviewing to interrogate, from away from interrogation, all of those kinds of things. So I think it would be a hard position for me to take, just because I think it is so unrealistic and to be so unpalatable to the public and to law enforcement. But I do, again, I'll reiterate a little bit of what I said earlier, is that we can't just have hunches and we start questioning people. We need to do that investigation work beforehand. And I don't have a firm sense of how often that happens, but I know that it does happen. And with our fragmented system that people have raised so many times today, how do we go about collecting that information and changing that mindset that we only, if we are going to retain questioning of suspects, how do we do it when it's not just a hunch that this person is a person of interest, which I think can be really dangerous.
Well, Jim, the reason why I asked that question too is from your perspective, if our goal, as you say, is to find the truth and not necessarily to establish the guilt of a particular person, there are other goals of that interview, and sometimes it is allowing a person to tell a version of events that was inconsistent with maybe the narrative that you walked in with. Is that true?
Yeah, absolutely. I think as I listened to Allison talk about it, right, and I'm not putting words in your mouth, but you're saying to go there, right, it's not what you're saying. Because it's a big step. Because again, I think we tend to, when we have these conversations about violations of people's constitutional rights and interrogation, the term interrogation, we're thinking about these cases that make TV, right? We're talking about 20 years later, somebody's cleared as a result of a DNA discovery. As DNA's gotten more accurate and the science is emerging to be very, very focused, we tend to talk about those bigger cases. But as I say here, I think about other cases where, I think of domestic violence cases where there's an allegation of some type of act of domestic violence. And, I've experienced where individuals are accused of acts by someone that turn out not to be accurate. And to afford them the opportunity to explain their side of the story in an interview, not an interrogation, I think is an important investigation, because that to me is a fair, balanced approach to. So if you just said, don't interview suspects in a crime, and you've got a statement from a victim on a crime against an individual, I'm not sure that's the way to deliver justice either. So it's not easy, right?
Well, in that context, often people are both suspects and victims,
Right.
and you don't always know.
That's exactly
Right.
right.
Yeah.
Right.
Yeah.
And so to afford somebody the opportunity to tell their side of the story about what happened, which could lead to, for example, another witness that you interview that gives you more clarity as to what's going on in a given situation. And again, I use domestics, and that's a real tough subject because many times in domestics, victims aren't believed. So it's not easy in those type of cases. So I think, Matt, to your point, there are a lot of cases where you should afford the so-called suspect an opportunity to explain their side of the story of what occurred.
Yeah, this also relates to the kind of the dignity and fairness aspects of these principles where we were talking earlier in the last panel about how, we can watch really horrendous interrogation videos online. There's increased public awareness that there have been some really nasty interrogations of people who got convicted in this country, some who've been exonerated, some it's, on appeal or actually the appeals have all been denied. That's corrosive to law enforcement legitimacy in a community. If people see that, if you go to police, because you go to your local, law enforcement agency to cooperate, and it turns into an interrogation, if you have law enforcement using deception, or even using these kind of narratives that would be very offensive in the courtroom, encouraging someone to sort of, sometimes officers are sort of to get on the side of someone. They're sort of glorifying in the violence of the crime, saying, "Oh, well, you probably did it because the victim had it coming to him," something like that. But those are the kind of narratives that can sometimes be effective at eliciting an inculpatory statement. But you have law enforcement siding with violence in the interrogation room, or lying in the interrogation room when you're supposed to be on the side of truth and non-deceptive behavior. And particularly, we want interrogations to be videotaped, but as there's more of a record of what happens in the interrogation room, it becomes all the more important that law enforcement behavior uphold high standards of legitimacy, just like law enforcement behavior out in the open on the beat needs to satisfy standards of dignity and fairness. You need to treat people with respect because that's what you do in a legitimate, cooperative, fair society. And somehow the interrogation room was seen as sort of, well, that's a box where you can kind of, anything goes. But that was never a good way to approach policing, to have this. We treat people with dignity and fairness outside of custody, but once we're interrogating you, then the gloves are off. We can do what we want. That never made sense from a perspective of even putting to one side wrongful convictions and accuracy, just from the perspective of treating people with dignity and fairness, because we want people to come to police with problems, and we want to solve problems, treating people with that kind of respect.
And to be clear, I'm going to follow up on that comment. To be clear, you're not suggesting that we can't both treat people with dignity and respect and still be engaged in what is arguably always going to be an adversarial process.
Yeah.
You're not
there'll be some
interview.
inherent coercion just because you wear a badge. Right.
Well, yes, and I guess my question is, to the law enforcement practitioners, the reality is people are going to want to sometimes withhold information from you. And I'm not suggesting that you be coercive, you treat people with dignity and respect, but at the same time, you have to recognize too that the conversation isn't going to be, did you do it? No. Okay, well, I'll see you later, correct? That you're not suggesting that at all, right?
Questioning needs to proceed. Yes.
Okay. and so I guess my follow-up question has to do with vulnerable populations, because there's been a lot of focus on vulnerable populations, and I'm gonna start with you, Allison. What exactly or who exactly are we talking about when we're talking about vulnerable people? Because it's unclear to me sometimes.
Yeah, no, if I may, let's step back a little bit again. But, I recently had the occasion to reach out to experts on interviewing and interrogation, people who often testify in court. Very informal survey, not a formal research survey at all. and asked them what they consider to be coercive in the interrogation room. And many of them picked up on this idea of feigning friendship or misrepresenting yourself as a friend, an advocate in the interrogation room. Because, you talked about the word adversarial. It is an adversarial situation, absolutely. That's why we have, our Miranda rights and, our constitutional rights. But it doesn't look adversarial at all. Again, we talk about the third degree and physical and, these psychological, it looks very friendly. And to think that the interrogator, interviewer is your friend in the interrogation room, I think is very problematic. And when we talk about vulnerable populations, that's even more true, because I think people with vulnerabilities, like juveniles or people with intellectual problems, mental health problems, they're even more likely to fall for some of these techniques or actually believe that the interrogator is their friend. I said I started this all 25 years ago, and at that time I was studying how to interview child victim witnesses, people, mostly children who allegedly had been sexually abused. And I'm sure, as I think many of you are law enforcement, you're very familiar with the infamous daycare cases that were going on in the 1980s. And so much science has gone into what are the proper ways to interview children suspected of abuse. We don't ask them suggestive questions. We don't ask them leading questions. For the most part, from what I've seen, it's been a minute since I've been involved in this, but now children are interviewed at child advocacy centers not by law enforcement, but by trained forensic interviewers. That was a disconnect for me 25 years ago when I saw how the progress that had been made with child victim witnesses, and I look at youthful suspects and how they were being. And if you look at the leading training manual on how to interrogate juveniles, it's basically like treat them like adults. Everything. If you survey law enforcement, I treat them like adults. You look at videotapes of juveniles, they're treated like adults. And I think we need to move away from that. I think more generally, we all come with vulnerabilities, and in some ways, law enforcement are very good at picking up on vulnerabilities. I worked on a disputed confession case once where the person was diabetic and needed to get their insulin. That person was vulnerable. So, I don't know how far we want to take a step back in terms of vulnerabilities, but I think if we were going to go forward with the reforms, I would focus on juveniles, people with mental health problems, and people with intellectual disabilities. And just like what we saw in the United Kingdom and other countries that have adopted more of the investigative interviewing techniques. And
and there are not a lot of agencies that have specific rules about questioning vulnerable suspects.
Mm-hmm.
Some are not really equipped to identify people that have severe mental illness, that are suffering withdrawal. There are some model agencies, and there's great IACP guidance on some of this, that do more than just say, for example, if it's a juvenile, maybe you notify the parent or guardian. Like that was about all we saw when we did a big FOIA Virginia agencies looking at their interrogation policies. And that was about all we got. There was none of this questioning juveniles in any particularly different way, except that you might notify a parent or guardian, and their presence might actually add more coercion. There are not that many agencies that have detailed guidance on, well, what happens if you should be asking some questions to become aware. Is this person intellectually disabled? Does this person suffer mental illness? Is this person suffering withdrawal? Are they Do they need insulin? Like there are quite a few different conditions, sleep deprivation, that can make someone highly vulnerable in the interrogation room. And in general, there isn't training or a procedure on it. These should be a standard part of both training and agency policies surrounding police questioning. Often they're not, or if they exist, it's sort of informal, like, oh yeah, maybe we call a psychiatrist, if mostly actually around issues of liability and being worried about a suicide if the person is left in the interrogation room, or we'll leave the cameras on if we're worried about the person harming themselves if they're left in the interrogation room. But none of this, well, if we're so worried that the person might be a danger to themselves if left in the interrogation room, what are we doing interrogating this person? And that has been a real gap, and it's a real need in the area of police questioning. I think that's a big area where there could be real improvement in attention from the law enforcement community.
Any thoughts, Jim, on that?
Yeah, I think, the point about not having policy is important, right? And I hate to be repetitive, but, in the world I travel in, there's the statement that, culturally eat policy for lunch every day. So policy is one thing, but leadership is important, right? And I think to Allison's point, she made a great point on the child advocacy centers that have emerged around the country. Mm-hmm. And I think if I've seen growth in the professionalism of law enforcement when it comes to interviews, I think the area around child sexual abuse has really grown drastically on the way, doing forensic informed interviews, trauma informed interviews, that type of training that's being done with law enforcement now, prosecutors, and even judges to a certain degree, to recognize what was in the 70s and 80s and probably into the 90s, real problems around, you talk about suggestive interviewing with a 5 or 6 year old. I think there's been a lot of growth there. There's been a lot of lessons carried forward, in my experience in law enforcement, from the approach now of interviewing those victims of child sexual abuse. So I think that's a very valid point, Allison.
All right, I don't want to take up too much time because I want to, with these next questions particularly, because I want to leave some room for audience questions. But I did take note of the fact that it was mentioned briefly in the earlier panel, and I know this is a discussion about police interviewing, but I think maybe you might have brought it up offline as well. There has to be some discussion about courtroom work groups and the responsibilities that interpersonal relationship between prosecution and defense and judges and advocates, and how does that interplay into the system and kind of, I know we don't have much time, but just in a brief way, what's the challenge for not only police, but for the rest of the judicial system?
Well, I do think that, the lawyers have a role to tell law enforcement, like, look, we don't trust the products of this questioning. It wasn't professionally done. It happens regularly that prosecutors will say, we just don't think the evidence here is adequate to go forward. In the past, there may not have been much awareness that there was a problem if there was a heavily contaminated interrogation. They might say, oh, the person signed a confession statement. Great, let's roll. And in the same way that I think, prosecutors would say, wait a minute, why did this victim not get sent to the Child Advocacy Center? Right? There would be awareness that this is a case where something unusual happened and that's not right. I think, ideally a prosecutor would say, this was a juvenile witness who interrogated for hours. Like, is this really something that we should be relying on here? Why did this happen? Ideally, vigorous defense lawyers, if prosecutors go forward with that highly coercive juvenile interrogation, bring motions in court, bring in experts, and raise awareness among judges that this interrogation has voluntariness issues. Courts are reluctant to exclude evidence, and the standards aren't wonderful, but there is a role for legislation in this area to go beyond the constitutional floor. We've seen a handful of states pass statutes saying that police can't use sort of aggressive forms of deception during interrogations. That's sort of a somewhat limited intervention. There are also quite a few states that have required videotaping, where at least that means that the prosecutor's defense have a record of what happened. They can see if aggressive threats were used or if contamination occurred, leading questions, some of the things that we've been talking about. And so there are good things that legislation and courts can do, but a lot of it is going to be just like Colonel Baker was mentioning about culture more than law, where ideally lawyers aren't just focused on, well, could we win? Will a judge keep this out? But is this really sound? Should we be going forward? We have an ethical obligation to be as careful as we can be if we're putting together a criminal case, and that will hopefully improve practices as well.
Thank you. For the benefit of the audience, I'm just going to summarize what I gleaned as the potential recommendations from this manual, and tell me if I've left anything out. First of all, I'll be fair, and Jim, I think you might agree. I was kind of surprised. A lot of these recommendations seem like things at least agencies in my area have been doing for years, and so it kind of surprises me a little bit that that's not maybe common everywhere else. But first is recording interviews in the entirety. Police should analyze and test the fit between the suspect's narrative and the crime scene facts. That just means corroborating the evidence. Ensure special protection of vulnerable populations. Minimize length of questioning. Avoid leading questioning. Ensure key facts are not disclosed to the person being interviewed. Avoid threats of harm as well as promises of benefit. Avoid the use of deceptive techniques that are likely to confuse or pressure suspects in a way that undermines accuracy of evidence. Ensure the suspect has basic access to physical and personal needs, including food, water, rest, and restrooms, and not to question the individual in an environment that is unduly uncomfortable.
Yeah,
I don't want to.
I would say that those are some of the specific things we said about how to conduct police questioning. We also said a lot about minimizing questioning of vulnerable individuals, right? That was a whole topic in these principles. Minimizing coercion. So there's quite a bit more than that, but those are important too.
Well, tell them what those things are.
Well, I guess so. We had that overarching principle that you began with, saying that in general, police should be trying to minimize undue coercion, which is a little vague, but in general, you don't want to be coercing people too much, and you want to treat people with dignity and fairness and trying to achieve accuracy. Those are very broad goals. But the idea is we want law enforcement to be trying to achieve those goals to the extent possible. Second, we say recording should be done. And I wish it were true that most agencies in this day and age are recording. There are quite a few states that require it, but there are quite a few states that don't. And in those states, when you look beyond the big agencies, it's not that common. We just finished a big FOIA of Pennsylvania agencies, and there's 1,200 agencies in Pennsylvania. It's a gigantic number. And most outside, very few outside the large jurisdictions require recording. We talk about rights invocations, that you shouldn't be just sort of following the letter of Supreme Court guidance. You should actually be trying to make sure someone actually understands their rights, which is particularly important with vulnerable populations, but it's true of everyone. People do not understand what the Miranda warnings mean typically because they're kind of confusing. We give some specific examples of things that can be problematic during police questioning, but in general, the idea is to, minimize coercion, minimize deception, gather information, like Allison was saying. And we highlight how with vulnerable individuals, this becomes even more important. And you should just minimize any questioning or avoid any questioning of such people at all. But of course, to do that, you actually have to screen and find out whether someone is vulnerable. And that's something that very few agencies have any guidance on. So that's a little bit more of a nutshell of what we outline in these principles, and actually operationalizing these principles. Let's say you love the section on vulnerable populations. We need to do that. We need to screen people who are potentially vulnerable and figure out how, if we do question them, how to do that in a very limited way. Well, how do you operationalize that in terms of police policy and training and culture? That's a big challenge and important, but there are not that many agencies that have tried to do that. So there's principles, and then there's turning it into model policy and practice. That's, I think, the next challenge.
Well, I know we didn't leave a lot of time But is there any question? Okay.
Hi, so I'm a colleague of Andrew. So I'm going to give a bit of it's more of a perspective, really. So before the university, I was a police officer in London for over 10 years, trained interviewing, did interviews with murderers, rapists. So it's really interesting listening to some of the things and just, I think the two things I picked up were like safeguards, number one. So some of the things you were talking about. So I think the Police and Criminal Evidence Act, or as we called it, PACE, was mentioned. That was like our Bible. And you talk about vulnerabilities. Somebody cannot be interviewed in England if they're deemed vulnerable without what we call an appropriate adult. So that is a safeguard that everyone gets. They're assessed by a healthcare professional, and an appropriate adult would be an independent person who observes the interview and basically ensures that the police are complying with PACE, the well-being of the person. So that sort of for me is like, I love listening to what you were saying, that wasn't being done. Sort of, under 18s can't be interviewed without that. So, I think safeguards is a really important thing to protect the integrity of that. And so the second one was just the role of the interviewer. We have different levels of interview in the UK. What are you actually trying to achieve? This idea that we police by consent, and if you do a bad interview, it undermines that. So really important that we train our officers in the UK is the mindset is you are there to be impartial and to gather evidence. So I just wondered, so it's a big long-winded question, but do you think it's all about really changing the mindset of a police interview or a law enforcement official? What are you actually trying to do? It's not a quest for the truth as such, it's just an account to test against the veracity of the facts.
Well, the idea of having an independent healthcare assessment, for example, that's something, there is often healthcare assessment before someone's admitted to a jail, including for liability reasons, but even there it's often very thin because the resources are lacking in terms of healthcare. Like it's not the screening you get if you're admitted to a hospital. And
if I'm understanding you correct, I think it's really important to be identifying these vulnerabilities, and I think I'm coming across it as extremely cynical. But I think it's so important not to, once these vulnerabilities are identified, not to use them to your advantage, right. to question the suspect and try to get a confession, because I've seen that all too often. I think I have a very selective set of materials or interrogations that I see, but I don't know. Again, I'm being very cynical, but I see a lot of following the letter of the law, but not the spirit of the law. So I do think we need to have a change in mindsets, similar to what occurred in the United Kingdom, but. I think it's going to be extremely, extremely difficult because of our fragmented system, and how do we get the knowledge that we've so carefully collected into the hands, and I know a lot of very smart people are working to do that.
Okay, I'm afraid this will have to be our last question just in the interest of time, but I'm sure they'll be willing to entertain questions offline.
Yeah, I just wanted to ask, hi guys, this is a great panel, about the role of interviews in U.S. policing, because my experience, like in the UK and in Europe, is actually there's way more interviewing outside the U.S. There's a lot less interviewing in U.S. policing than in Europe. Like our colleague just mentioned, like every single case, everybody comes into custody, there's an interview, and it may just be a basic one to take an account, but you're actually getting way more access to people than you do in the U.S. And it's partially because of the safeguards and because they have lawyers there, defense lawyers in the room, in the interrogation with you, so people know that they're protected. So it's not a situation of trickery. And it creates a sort of rapprochement. So it's not so zero sum, where it's like the only way you can get access to someone is to trick them into talking to you. That's how it is in the U.S., right? Because of the zero sum attitude we have. But just to think about safeguards as a way of making it a situation where people are in a position of safety to talk to you. So it's just interesting what you talk about, but I don't see it playing out that way in the U.S., Allison. And like when we're studying the impact of laws, like the laws that provide access to counsel for kids in California when they get arrested before they're interrogated, a lot of what we're finding is like police just aren't doing interviews then. So like, I got to call a lawyer, I'm just not going to do it.
well, it's sort of like if we won't do it for kids, then where are we, right? We just had Brian Stevenson come speak at Duke, and he's sort of like, you do kind of need to judge yourself as a society, at least as a starting place in terms of how do you treat kids. And if you're treating kids like presumed criminals and not giving them a lawyer or treating them with sort of basic dignity if you're coercing kids, that's not a good starting place.
You know, the only thing I would want to push back against, because you make it sound like all interviews are done through trickery. And I have to push back against that because, you know, I know of many, many cases where there isn't trickery used. It's an approach that, you know, and I agree with you, that trickery can become very intimidating. I said this earlier. There's a power differential that occurs naturally between a police officer and a citizen because of the power police officers possess. But in a lot of the more sophisticated approaches to handling criminal investigations now, it's a well thought out process when the approach happens to a suspect or a witness, and it's choreographed. It's not trickery. It's well thought out in a major case investigation. So, I mean, I just have to.
Totally. I'm really sorry for leaving that impression. I meant only that in this country, if there's a lawyer attached, unlikely that you're going to get access to that person. So you're in a position where you have to convince someone to speak to you, to waive the right to a lawyer, to waive the right to silence in order to get access to them. And that's not the position that British cops are in. They can get access to people without having to convince them to waive rights. And that's an advantage that they have. I'm just talking about the incentives you have.
I get what you're saying, and I don't disagree it occurs. But what I'm saying is, and I'm being repetitive now, as forensic evidence has become better, you know, you're less reliant, like as a young trooper back in the 70s, you're less reliant on confessions now. And there was pressure to get that confession. It's much different today. Now, I agree from my perspective of being at IACP and working across the country. There are some horrible stories out there about the way interviews and interrogations have gone down. I mean, I can't disagree with that.
Well, I want to thank you. I know we certainly could probably spend all day talking about this and maybe even all week, but if you wouldn't mind giving me this panel a hand.